Explain how people should know kind of up front whether they have a claim at all. Just because you've been in a wreck or an accident, just because you've been injured, isn't a guarantee that you have a case that would be successful. Give us some of the main talking points.
Well, there's three really basic foundational sources of liability. One is somebody does something intentional to you. They lie about you. The president's been talking about defamation recently. If somebody just outright intentionally lies. Well, what about if you don't really mean to hurt somebody, but you do anyway through inattention? That's negligence, and that is a basis for somebody suing you and successfully recovering. Third one is strict liability, and that one is if you use something, say for example an explosive, and you injure somebody, well, you don't have to prove negligence or causation. Boom, if the explosion hurts you, then they are strictly liable.
Now those first two are simple. I understand them both. That strict liability sounds like that could get very complex well, depending on the case.
It can, but if you think about it though, Mike, something that's inherently dangerous like explosives, your duty is a lot higher to be careful. And so going in, if you're hauling nitroglycerin, if something happens and it blows up and you injure somebody, you don't have a defense.
If you like to go to the shooting range and shoot a gun a lot and you somehow shoot yourself, you're expected to be safe with that weapon.
That's right.
And so that liability would be very tough to bring
in. It is, and there's one other thing in negligence. You can assume the risk. Like when you go to a baseball game, for instance, and foul ball hits you, well, people foul balls there, and so you kind of assume that risk. Well, you cannot assume the risk of something like wantonness, strict liability.
Yes, okay.
So that's a big difference.